Very good afternoon to all our present participants in the meeting, to our worthy expert speaker, Khushal, who is General Manager at Ennoble IP. Introducing our expert speaker, Khushal Juneja. He is an experienced IP professional with a demonstrated history of work in the legal IP services industry. He is skilled in patent research and analytics, patent prosecution, trademark, and design prosecution. He has a vast experience in customer service, client management, engineering, accounting, and taxation. His experience in client handling and currently associated with IP cell of more than 50 universities and educational institutes, plus 100 plus SMEs and startups. So we are really honored to have him with us. And today he will be sharing his expert views from his domain with all our participants in the today's session. So over to you, sir. We are really honored to have you with us today. You can just continue with the session. Thank you so much.
Thank you, ma'am. Thank you for the introduction. So, good afternoon, everyone. Hope I'm audible, ma'am. Ma'am, can you please confirm if the presentation is visible?
Yes, it's visible. You can please go ahead. Thank you.
Thank you. So good afternoon, everyone. So today we are basically here to understand the basics and terminologies of intellectual property rights and to celebrate the this year World IP Day, that is World Intellectual Property Day. And we have a specific theme this year that is related to youth only. So the title for our World IP Day theme is IP and Youth Innovating for a Better Future, right? So I hope we know that some of us might be already knowing the terminology of intellectual property right, what is patent, trademark, copyright. Some of us might already have filed it, right, or maybe involved in any kind of startup or doing some innovative work. So we are just going to synergize ourselves on the same line, and we'll be discussing and giving you information about all those things, that how you can apply for a patent, trademark, what is the right time. Along with that, we'll give you few examples about simplest technologies developed by students and college going students or school students around the world, so that you may also have an idea how simple it is to create some intellectual property and to protect it, right? So moving further, we should first understand the basic terminology. What is intellectual property? So as the name suggests, it's some kind of a property, right? So property, fine, it's a property, but what the term intellectual here suggests? So it is basically creation of human intellect. Now, if we talk about the word intellect, intellect means whatever knowledge we possess. So अगर हम इसको हिंदी में बोलें तो हमारी बुद्धि बौद्धिक क्षमता, जितनी भी हमारी इंटेलिजेंस है, हमारे पास whatever knowledge we have, either we have obtained that knowledge from our parents, from our friends, from our college degrees, for school studies. So whatever knowledge we have, right? So by using that knowledge, whatever we are creating, either it's an idea we are creating, either some kind of character we are developing, either some artistic work we are creating, or we are writing a script for a movie, we are writing a research paper, developing a book, writing a book, or doing some choreography work, cinematography work, or even clicking a photograph picture also, right? So whatever these things that have been created with the help of our knowledge, with our intellect, so this is intellectual property in simple terms. So our ideas, our thoughts, our creative work is our intellectual property. So now, to protect these intellectual property, there are some exclusive and monopoly rights provided by Government of India, and those rights are called intellectual property rights. Means those rights will give you exclusive protection to your ideas. That means if you have some certain idea related to technology, related to a book, related to some kind of a software application, then that property belongs to you, and how it can be enforced by using those certain rights that are provided by Government of India. Now, it is basically a knowledgeable asset, as I've already told, just like you have mobile phones, gadgets, those are your physical assets, right? Those are your tangible assets to which you can touch and feel. Our intellectual property is our intangible asset, because initially it is in the form of only ideas, only thoughts, right? So it is our knowledgeable assets. Plus, it is also a key component for success in every business. whether you are going to do upon your own startup or open your own venture. So you need to have some certain types of intellectual property, or your assets should be protected under the intellectual property right, so that no third party or no competitor can utilize the name of your company, right? So for example, if you have a startup, let's say Zomato, so the name of the company Zomato should be protected under intellectual property right. Then the complete application, then the trade dress, how the application is working, their source code, object code, all those things should be protected under copyright. Then the application part of it should be protected under patent rights, right? So, and if they are delivering the products or the food to your homes in some certain specific boxes, so the outer appearance of box should be protected under design registration. So all these things we'll be discussing in detail in the further slides. So it's just that these are few of the attributes that this is the creation of human intellect, tool for competitiveness. Plus, it also plays a major part in creating the wealth for every nation. So with the increasing industrialization, the fourth revolution is about to be here, right? So every industry needs protection, because in India, if we are developing something and our industries, if developing something, it should belong to us, right? If other country wants to use it, or if the companies outside India wants to use it, they should take approval license from us so that we get the monetary benefit. Why? Because the first idea of creation or developing some technologies belongs to us. So in a certain way, it helps us in generating wealth also. It helps in increasing the innovation index also of every nation. Now, so there will be no self-reliant innovation without protection of IPR. So the main concept behind giving protection to the intellectual property, because physical assets are already protected. You have house that is protected. You have vehicle, it is protected, right? The basic idea, the basic reason to give the rights to intellectual property is to promote innovation, to promote the efforts, to incentivize the inventors. So being a school student or being a college student, if you are developing something, if you are giving some extra time in developing something, so you should be incentivized, right? You should be given some monopoly, you should be given some exclusivity to the creations that you have developed, because your mind has also done some labor to create an idea can be a simple idea also, right? But your mind has done some kind of labor, some or other kind of labor, and put some effort, have put some efforts in developing that idea. So it's just a way to incentivize the inventors and to incentivize the innovators. So there are intellectual property rights that give you exclusive protection. And in another way, we can say that these rights are given to respect the work also, to respect the knowledge also, to respect the talent, and to respect the creation that you as a student, you as a faculty member are doing, right? 5% on his first. Now, in the further slides, we are going to study that how it applies to your research work. A research work, that means if you are developing any product or process in your college, or doing any major project, minor project, and how it applies to your inventions, how it applies to your innovative work, or maybe the artistic creations that either you are doing in college, university, or school, or maybe while sitting at your homes. So on this slide, I have given a brief introduction about all kinds of intellectual property rights that we are going to deal with them today, right? So the first is patent. So patent, what is a patent? Basically, patent is a legal certificate. Just like you have RC for your vehicle, right? So patent is also a legal certificate that will give you protection to the technology. Technology, either a product or a process. That means if you have developed some, let's say, wireless mouse, right? So either you have developed a final wireless mouse as a product, so this product can be secured under patent rights, or you have developed a process to develop that mouse. So either process or product, both gets protection under patent rights. Now this is given in the form of a legal certificate. So once you have a granted patent, that means your idea, your technology is secured, and no one can use that particular technology without your permission. Now, moving on to the next, we have is trademark. So trademark is basically those mark which represent your services and goods in the market and can help you to distinguish your goods and services from your competitor. So in simple language, this is a business identifier. That means through which your customers can identify you in the market. So trademark can be a logo, can be a name, symbol, sound, shape of goods. Then third we have is copyright. So copyrights are basically expression of thoughts. So expression of thoughts means in whatever form you are expressing your ideas. If you are writing a book, that means in written expression, that work will be protected. If you are singing a song, so the sound or the lyrics of that you have developed, that will get protection. If you are performing any choreography, so your shapes and moves will get protection. If you are doing any cinematography work, developing any codes, that means writing a object code or a source code for an application, so in whatever form you are writing that code, that form will get protected. So copyright means expression of thoughts in the way, in the process, in the type you are expressing your ideas, that will get protected. Fourth we have is industrial design. Industrial design basically protect the outer appearance or shape of any product, how it appears from the outside. So you might be having your smartphones, right? So Apple and Samsung, or Apple or Nokia, they have different set of smartphones. So no, you will never see that two different smartphones having the same shape, configuration, or even the size, because every company is protecting their designs that they are developing. So basically, industrial design provide protection to the outer appearance, your laptops, your vehicles, your two-wheeler, three-wheeler, right? So all these things, even your clothes also get protection under industrial design. Then fifth we have is semiconductor and layout design of ICs. So this is basically the 3D layout. So I hope many of us might be knowing about what is an integrated circuit. So every circuit is designed to perform a particular task, right? So there is some 3D layout imprinted on the circuit. So that 3D layout gets protection under this particular law that is called semiconductor and design layout of ICs. Now, moving on to the next, we have few more types of intellectual property right that we are not going to study in detail, but I'll give you a brief information about them. So first is trade secret. So as the name suggests, those things which are meant to be kept as a secret. Secret means because see, all the previous 5 intellectual property right that we have studied, these will get published after a certain period of time. And publication means other people will get to know about it, right? But there are some things, some business ideas, some business methods, some chemical compositions, some formulations that we want never to become public. Because if it become public, so other people will try to use it or maybe modify it as per their need and come up with a new product in the market. So many of the people around the world have tried to keep their business methods, kept their chemical formulation as a trade secret. So the famous example, if I can give you, is of recipe of Coca-Cola drink. So no one knows what is the actual recipe of Coca-Cola drink, right? In a similar manner, we have another examples, right? For example, the KFC chicken burgers. So there are some 11 spices, 11 type of herbs that are used in KFC chicken burgers, right? So those herbs and their compositions have been kept as a trade secret by the KFC company, right? So these are those things which you never want to become public, or your business owners will never want to become public. Then another we have is geographical indication. Geographical indication is basically an indication tag. What we say it as indication tag, that means it is given to those products that belong to a certain region. Product can be an agricultural product can be a natural product can be a manufactured product, right? So those goods or products that are generated or originated from a particular region, because they are giving some certain quality standards, they have some certain characteristics, some certain attributes that you can never find in a similar product if it is coming from another place. So in a sense, that product have some certain quality because it is being originated from a certain area or a city or a region. So the example of geographical indication, all we know, Darjeeling tea, right? So we always associate the names of the state or the city with the product, Darjeeling tea. Then we have Paris perfumes, right? So the perfumes that are being coming out of the Paris country, right? So they have different set of qualities, fragrance, the concentration of the perfume. Then another example, Kolhapur chappal, Banarsi silk, right? Nagpur ke oranges, right? So these are few of the examples of geographical indication. These are not given to any individual person, because see, as an individual, I cannot protect it. But if in my area, other people are also involved in developing similar kind of products, then we as an association can apply for the geographical indication tag, and we will be the only authorized users or authorized developer of this particular product. and we can only use that. If I am from Darjeeling, then I can use the tag of GI tag, that means Darjeeling tea, on my products. In a similar manner, you have seen that there are many examples of related to it. You will relate to it in the future times also. If you see that name of city is written on the along beside the name of the product, so you will get to know that it is a geographical indication because it is giving some certain quality. Then another types of IPR we have is domain names. So domain names are nowadays considered to be protected under trademark only, but if you want to get it registered, so there is a separate place of registrar of domains where you have to apply for it, right? So these domain names also represent your identity in the online market. So for example, iplt20.com, cityuniversity.ac.in, right, or edu.in. So these domain names are also kind of your intellectual property. Now moving on to the next we have is patent. So what is a patent? So patent, I have already told in a brief manner that patent is basically a legal certificate that will provide protection to the technology you have developed. Now who can apply for a patent? Any inventor, either you yourself can apply, or you along with the university can apply, you along with your parents, friends, your family members can apply for a patent, right? So now what things are given a patent? So patent हमें पता है, we have understood it's a legal certificate. I'll show you also one example. So this is a legal certificate. This is a patent certificate given to a university, right? So in this form, you will get the certificate, your name, application number, date of filing will be written on the certificate. So now, what all things will get protected? So first criteria I have told you, there is a technology. So technology is must, either a product or a process. Either you have invented a new product of any smartphone, of any sensor, of any microcontroller, or maybe as a software application you have developed as a product, right? Or process, that means process of developing a sensor, process of developing a mobile phone, process of developing a wireless mouse, right? So these process can also be secured under patent rights, but there are some certain conditions that a technology should fulfill, because technology is the basic criteria for a patent. Then what kind of technologies will get secured under patent rights? First is novelty. That means your technology should be new and unique in the complete world. Either complete technology should be new, or there are some certain new components added to it that is making the technology new for the very first time in the world. Second criteria is usefulness. That means it must be functional and operative, or in a layman language we can say that the technology you are developing is capable of being reproduced or duplicated in the industry as well. So other people should be able to use it. So it is basically for the society, right? Not for your personal use. Then third we have is inventiveness. By inventiveness, we means to say that there is some technical advancement over the existing technology. So every time it is not necessary that you are coming up out with something very out of the box that has never been developed, right? You can see simplest things uh, that are there in the market, and still with the new things coming into the market, patents are filed for them, because every time you perform some certain modification or improvement over the existing technology, then you can also apply for a patent on your own name. So the kind of smartphones we are using, right? So smartphones that were in 2010 and smartphones that are in 2022, both are smartphones, but the technology shift that has taken place, it has not taken place overnight. 12 years it has gone by to develop this kind of technologies, right? So every time some improvements are developed, some improvements are made, a new technology is launched in the market, right? So these are few of the criteria you need to keep in mind while applying for a patent application. Now this is just for your information that first exclusive right, that means first monopoly over an invention, was given to the inventor named Filippo in the year 1421, and the technology was improved method of transporting goods up and down the river Arno in Florence. Now what can you patent? So this is a simple example of a door lock. I hope everyone can relate to it, right? So door locks you already know. So either you have developed a complete product, that means you have invented a new door lock, complete door lock. So that can be protected as a patent right, or there is some composition of the lubricant that you have developed, then that lubricant can be secured under patent rights. Third is you have not developed a lock, Rather, you have developed a machine that is making the door locks, right? So in a way that apparatus can be secured under patent rights. Fourth is you have not worked on the door lock or the machine. Rather, you have developed a new kind of process to make a door lock. So or a method of making a door lock, right? So that can also be secured under patent rights or an improvement of any of these. So if these products are already into the market, just try to see that how you can improvise them, how you can make them more technically advanced so that you can also apply for a patent for your own. As I already told that 90% of patents are for improvements to existing patented inventions. So it means that technological shift doesn't happen overnight. So every time an inventor has to come up with a problem into the existing technology that is there in the market. If you are able to solve that existing problem, then maybe you can apply for a new patent application for your own. So I'll give you a brief example which you all can easily relate. So in 2010, smartphones used to have a single camera, right? So initially a single camera was there, that was also a smartphone, but some inventor identified a problem in the single camera, that with the single camera you cannot capture images at much higher definition. So he introduced the concept of dual camera. Camera was already invented, right? But he only found a problem into the existing technology and solved it with the addition of second camera. That now with the addition of second camera, you can have images at higher definition. Then in 2014, another inventor found a problem that dual camera is also not sufficient to capture the images at a wider angle. So he introduced the concept of triple camera, that with the help of third camera, now you can capture images at a wider angle. That means wide area can be captured in a single image, right? So this in this way, how a technological shift take place. So another example which I can give you is of WhatsApp. So WhatsApp you all are using. WhatsApp when it came, it was 2009 or 8, I think, right? So in 2009, when WhatsApp was launched, multiple patent applications were filed to secure the complete WhatsApp application, right? But this to this date, we are receiving continuous updates from WhatsApp. And with every new update, what we get is what are the new bugs that have been removed? What are the problem that has been removed? What are the new features that have been launched, right? So with every new update, WhatsApp is filing a separate patent application, not to secure the complete WhatsApp, but to secure only those features that have been launched by WhatsApp. So I'm giving you these examples just so that you can relate that don't need to come up with the products that are never existing, that have never been existing before, right? You just need to see the products around yourself, technologies around yourself, instruments around yourself, and try to improvise those existing technologies only, either by way of developing software applications for them, or maybe attaching any new kind of hardware or new kind of sensors to them to make them technically advanced, or because current generation understand the problem of the old generation devices, right? So you just need to find out those simplest devices or maybe difficult devices which you can work upon, which you can research upon, right? And just try to come up with your own technology, come up with your own process or methods to make those old fashioned technologies more advanced as per the current needs. Now, this is just an example I have given of a mouse trap. So both are patented products. So there were three problems that were solved in the first product. So the first problem was plastic that have been metallic strip that have been replaced with plastic. Second problem was size of the spring has been increased. Hook has been provided at the end of the arm. So I have given you this example just to show you that how small a problem can be, right? So a patent is granted for a period of 20 years. That means you will enjoy the exclusive rights for your technology for a period of 20 years only. After that, it will become public, but for a period of 20 years, you can only exploit it, manufacture it, use it, sell it, or distribute it. Now, these are few of the examples of pins, either hairpin or maybe board pin or paper clip, right? So these are the simplest technologies that once they were invented, patent applications were filed for them. Now, I have recently heard a new technology that the board pin. So the moment you grab the board pin, it will tell you exact amount of force required by your thumb, index finger, and your hand to punch the pin into the board, right? So now you can imagine how people around the world are still trying to improvise the simplest technologies. See, because the end user of technologies are we only, right? We are only going to utilize these technologies. We are going to make our lives easier if some new technologies come into the market, right? So this is just a way of giving you example that you don't need to every time select an aeroplane only or a big machine or a big transformer only to work upon. You can see the simplest things, right? Now, his name is Hideshwar Singh Bhati. He is the youngest patent holder of India. So he is a crippled boy, right? So he found a problem that how multiple players can play chess at the same time. He found a problem, developed a solution of a multiplayer chessboard. Now he has successfully filed a patent for it, right? He is only of 9 years of age. So my way of just giving you this example is you don't need to be some technological person also to file a patent. Patent can be filed by anyone, maybe a street vendor, maybe a vegetable vendor, or maybe your house cleaner also. What you need is all you need is a problem solving attitude, right? So in India, there is a famous saying that jugad. So we Indians are more inclined towards doing jugaad rather than securing those jugaad, because sometimes those jugads are also kind of method and process that help you in improvising the existing technologies, right? So that's why India is very far behind than China in protecting their innovations. So in India, we are filing close to 60,000 patents per year. And if we talk about China, China is close to 14 lakh patent applications per year. So in a way, if we are comparing ourselves in population with China, we are very far behind in terms of innovation or basically protecting our innovations. Now, this is a few example of an innovation developed by a student from a university only, right? So just like the theme today said that IP and youth innovating for a better future, right? So this technology was also developed by a student during the monsoon season. So what happens is it is very difficult to carry umbrella and bag together. So he found the problem. He developed a solution that why not to integrate the umbrella into the bag itself, so that whenever the rain droplets will come, the bag will automatically detach out the umbrella, and the mechanism or the kind of materials that he has used, it is not increasing the weight of the bag also. So this is just an example, right? Another example of a liquid recycling system. So this filter was developed by a faculty member during the lockdown period. So this is a small filter, portable filter we can say, that can be installed in any pipeline to give you clean drinking water. Another example, this is a non-rotating card holding apparatus. So basically this is your iCard. So iCard we all wear, right? So I'm also wearing right now. So there's a problem with the iCard that whenever we run or move ahead or move fast, so the front face of the iCard or the frame of the iCard will get rotated, right? So this was the simplest problem. So this student find out a problem and solution for it, that he has made the strap as non-rotating, or we can say the strap with non-rotating shape, so it will not rotate, or somehow if it gets rotated it will automatically regain back its position as it should be. Now another example of a BBA student who has filed more than 10 to 12 patent applications. So he is from BBA and he initially used to not have those kind of technological mindset, but now with the past few working years, 2 to 3 years, he knows every kind of technology. But initially what he used to do was he used to take help from his faculty members, from his colleagues, so as to file patents. Now moving on to the next, we have is trademark. So what is a trademark basically? Trademark is those kind of mark which gives you identity in the market, or basically from which your customers can recognize you in the market and can differentiate your goods and services from your competitor, right? So basically trademark is a word, a design, a combination of these things that are used to distinguish the goods and services of one person from the others in the marketplace. Now there is a tick mark on your screen, so I don't need to tell you to which company it belongs, right? So because these companies are spending so much on their branding, marketing, that now customers can easily recognize their marks through their logo only. Trademark can be used to uniquely identify a brand, and as I've already told, So it is very important that every name of the company or even a small shop should also be protected, because there are always chances of copycats. See, once you become famous, once your startup will become famous, right? So there will be copies of your name in the market, of your products in the market. So how you can stop them? If somebody else is using a similar name or a closely related name to your company name, so if you have a registered trademark, then you have full rights to stop them, full rights to file a case against them, or can seek for the damages or can seek for the remedies that are available in the law. Remedies can be injunction, maybe damages or accounts of profit, right? So there are multiple remedies available in the law, and trademark protection basically always gives you a kind of a sense of a authorized brand also in the market. So you must have seen that TM symbol or R symbol that is written on the trademark. So the TM means trademark has been applied, and when you see a R symbol written on the name, that means trademark has been registered. Now trademark is granted for a period of 10 years. That means if you are applying for any application today, so 10 years you will have the exclusive rights. After that, if you want to continue with your trademark, you can again file for a renewal application and you will again get for it for 10 years. So basically it is for lifetime if you are able to get it renewed after every 10 years. Now third we have is copyright. So copyright is basically those rights that are derived from any original literary, dramatic, musical or artistic work. So as I've already told that copyright is expression of thoughts, expression of ideas in whatever form you are expressing it. Now that can be a literary form, dramatic form, musical form, or an artistic form. You must have seen that C symbol at many places, right? So that C symbol basically denotes that your rights have been reserved by the author or the applicant. And this C symbol can be seen in the bottom of websites and the starting of books, right? So copyright is one of the oldest right in the term history of intellectual property rights. And if we talk about international agreement, so there's one international agreement called Berne Convention that basically regulate the copyrights in the international domain or maybe the other nations as well. These are few of the examples of copyrighted work, and just like Canadian novels are there, right? Now this is a list of things that you can trademark. Like script is there, movie scene is there, actor interpretation, cover, movie editing, pictures, right? Now, copyright is granted for a period of 60 years plus life of author. So suppose I am the author of any particular work and the day I will die plus 60 years rights will be transferred to my legal successors. And copyright cannot be renewed as of now. Now, fourth type of intellectual property we have is industrial design, right? So the visual features of shape, configuration, pattern, ornament, or any combination of these features that are applied to a finished article made by hand, tool, or machine. So basically the outer appearance or the aesthetic value of any product will get protection under industrial design. So there are only two conditions to file an industrial design. First is design should be original, and the second is it should be either 2D or 3D. So design such as those featured in the products are known for their visual appeal. That means any product that have a visual appeal. It can be your clothes, it can be your branded watches, your shoes, your cars, your vehicles, your mobile phone, your gadgets, your earphones, right? So all those things that have a visual appeal can be protected under industrial design. So in India, we call it as industrial design. Outside India, they are called design patents. Now, fifth we have is integrated circuit topographies. So as I've already told that the 3D configuration of the electronic circuits. So if anybody is involved in developing these kind of 3D circuit, we can have a separate session for them. We can guide them that how they can secure their ICs if they are developing, right? So this is basically a 3D circuit, 3D configuration of the electronic circuit that are embodied in the ICs or the product layout or the designs of them. ICTs are basically, or we can say semiconductors or ICs are used in every technology, right? Either you are using computer, automobiles, pacemaker, industrial robot, your cameras, your spacecraft. So in almost all the technologies, ICs are being used. Now, a design patent or basically a semiconductor design is given for a period of 10 years, and it can be renewed only once for a period of 5 years. That means it means totally 15 years you are going to get protection for your designs and semiconductor layout designs. Now, this is a single product having all types of intellectual property rights. So I'm giving you just example of a BlackBerry smartphone. So the smartphone having a display technology, right? So the technology of a display is a patented technology. That means there is some working, there is some function of the display, right? Second, we have is name of the company or the logo of the company, that is BlackBerry. BlackBerry is a well-known trademark also, and the registered trademark also by the owner of the BlackBerry. Then third we have is industrial design. So the outer appearance, shape, configuration, or the assembly of the smartphone, that how it appears from the outside, how it appears from our naked eyes. So that appearance or that assembly will get protection under industrial design registration. So I have given the name, original application number, their services, the brief description, and the owner also. Then this is another example of a medicine. So medicine, the composition or the formulation, the ingredients that are used to make a medicine will get protection under patent rights because that's a technology. Or the name by which customer identified in the market, that's a trademark, that is a CIPRO given on your screen. Similarly, for the COVID vaccines, we know there are two famous vaccines, Covaccines, Covishield and Covaxin, right? So both the names will get protection under trademark rights, and the vaccine or the composition of the vaccines will get protection under patent rights. Now there are few benefits of performing IP searches. So IP search means basically to see and to understand that whatever you are developing or conceptualizing or whatever you idea you have, it should not have existed before, right? So because it happens, there are very high chances that whatever you are developing or trying to develop, same thing has already been invented or developed by some other person in different region or maybe in different country, right? So it is very important to perform a basic patentability search or in-depth search to understand the complete technology or the complete idea. So basically IP search will help you in performing or identifying the trends and new development, that what kind of development have already been made into this particular set of technologies. It can help you in generating new ideas. It can also help you in gaining competitive intelligence, or sometimes maybe it can also help you in licensing your new products or services in the market. It can also help you in solving technical problem. So IP search you can do on Google. Just go to Google, type Google patents. It will be a similar dashboard like Google only, but here you will get different patent applications filed by different companies, right? I'll show you also one example how you can perform it. So I'm sharing another screen to just show you that how you can perform a Google search yourself. So I am going to Google. I'm typing here Google patents, right? So this is the first link. I will click on that link. It will be a Google patent dashboard. Now, if you want to search any technology or any kind of thing you like, let's suppose I want to search pen drive with fingerprint, right? So this will give you all those patent application that talks about pen drives or or we can say serial bus, universal serial bus controller. A USB flash drive having locking pins and locking grooves with fingerprint authentication, right? So USB drive, you can see how kind of technologies or what kind of developments have already been developed in the USB, right? So this is just an example to show you, type the keyword here or the technical keywords to understand that what kind of technologies have been developed. Mobile cover with fan. So here I will get all the mobile phone cover that have already integrated fan inside it, right? So those patents, if I want to see that whether this kind of technology has been developed or not. So here I can just perform a Google search and check what kind of technologies have been developed or launched into the market. So now this was all about today. So if you have any further inquiries or questions, you can please ask. Or if you want to have more information regarding the IPR technologies or some related things, you can visit a channel that is IP Jagruti. So this is a YouTube channel where you can have detailed information about myths, about the pros and cons of filing a patent application or a trademark application, and what are the recent developments in the technologies into the market. Now I'm open to questions. If you have any doubt or any query, you can please ask.
Thanks, Kushal. There are a few questions in the chat box. One is who filed the industrial design? A question by Gitanjali Arora.
Yes, ma'am. So, ma'am, where I can see the questions?
It's in the chat box.
So who file industrial design? So anybody can file for industrial design. So see, it is not necessary that only industry can apply for industrial design. If you have come up with some new idea of a, let's say, chair, right? You have come up with a new chair that can help the physically disabled persons. So you can apply for the design of that particular chair. There must be some extra components you have added, right? So for filing a design patent application, you only need to draw the complete all side views. That means the 6 side views: front, back, left, right, top, bottom. And either you need to draw the views on paper, or maybe you can draw the views in a particular software, or maybe if you have already developed prototype in your hand, then you can click the pictures also of the all 6 sides and send it to us, or maybe to your IPR cell that is being taken care by Dr. Harmeet sir, right? You can reach out to Dr. Harmeet. He will provide you the form. So there are separate forms for making applications, separate form for patent, design, trademark, copyright. So you can take any form. He will provide you the form, fill that form, send it to the IPR cell. We will help you in the complete process of filing, registration, grant, or maybe after commercialization also.
So second question again,
how Ennoble IP helps startups to get patent. So we will help you at every stage. So the first basic thing that you have to do is conceptualize, find a problem, develop a solution. Or if you have already done that, reach out to your IPR cell, reach out to Dr. Hamid sir. He will give you the form, fill that form, send it to us. Then we will get in touch. Our team will get in touch and we will guide you in the complete process of filing it or granting it. Is it important to file a patent? Yes, according to me, it is very important to file a patent because see, there are benefits associated with it. You can judge yourself whether it is important for you or not. So one, yes, directly it is going to increase your worth in the market. Just like every startup has a worth in millions or billions of dollars, right? So as an individual, as a faculty member, as a student, as an employee, what is my worth? My worth is my resume or CV. So what kind of studies I have done, what kind of extracurricular activities I have done, how many research papers I have published, how many patents I have filed. Because being from a technical background, if I go to apply in any company, or want to give an interview any company, so the person sitting in front of me will only check my capabilities, my technical aptitude, my problem solving attitude. So patent filing directly means that whenever you will face any problem in life, you will always try to solve it. So in a way, you can say that it is going to increase your worth in the market. I have separate multiple examples where students from different colleges have got high packages just on the base of filed patents in their resume. Multiple example where students have lost thousands of rupees, lakhs of rupees, or even millions of rupees, where they were not knowing about the importance of intellectual property and they have signed the agreements. Because during internship, what we do, we were eager for only our certificate, but we never know that what kind of technologies we are developing for any industry, right? So during the internship, there was a student who has developed a technology for JCB, and JCB has launched that technology into the market, and it's a very famous technology also. I will not name the case or the person. So, but that particular student didn't got anything. It was a completely wastage of money for him, right? Another example, multiple examples I have, which I can give you in my further sessions, which you can find that patent filing, yes, benefit for monetary benefit also, for your career benefit also, for your education also. How is patent different from copyright? So see, patent is basically only for the technological working. Technology either a product or a process. Copyright provides you protection to the expression of thoughts. Copyright will not provide the protection to the working of any technology. अगर आपने if you have developed a technology also and you have written the working of that technology on paper, so copyright will only provide you protection to the in whatever form you have presented it. That means you have written it on a paper, right? So the expression of the paper or the way of your writing will get protected. It will not protect the working. So working will can only be protected by patent rights. So in a way, it is completely different from copyright. How to start career with Ennoble IP? So once you are done with your graduation, you can drop your resumes to hr@ennobleip.com. So every month we have new vacancies coming in. If HR select you or if you are a good candidate, you can definitely work with us. Next question is, what if we still have to get a patent, but on my idea, a friend of mine do so on my idea? Is there any way I can file complaint for him or her? Yes. So you can always file a complaint, but to support your argument or to support your case, you should be having legal evidence. So suppose your friend are working on the similar idea, but your friend files before you without intimating you, right? So you must be having some conversation related to that technology, some exchange of conversation either on WhatsApp, mail, or telephone, or maybe on a piece of paper also, right? So if you have those evidence, please reach out to your IPR cell. We will help you either by internal discussion or maybe let's see that if you can file a case in court also. Anyone else have any question, please?
I think there was a question. Correct me if I'm wrong. I think we skipped one question from the chat box. How do I apply for another country patent like European patent or US patent? Are we done
Yeah,
with it?
yeah. So I missed that. Just a second. So for applying a patent in a European countries or a US patent, so process is similar, right? So whatever you are filing it in India, you can file the same application in different countries because see, IP is geography specific. So if you want protection in India, you need to file it in India. If you want protection in different countries, so for every country, you need to make a separate application or maybe a common application through a PCT platform, right? So if you want to apply, you need to reach out to your IP cell because generally filing a patent in US is 6 to 7 times more costly than India, right? So for that, we need to take separate permission from the college or the university. But in India, if you wish to apply, it is totally free for you guys if you are associated with city, university in any capacity. But for other countries, maybe your college will give approval or maybe you have to contribute in the financials. Process is same. We will file on your behalf in those countries. So we have associated in all the countries where you can apply for a patent. You only need to give us the instructions. Rest, all the work will be done by your attorney. You don't need to go in different countries to file for patent. Any further questions from anyone?
I think, Kushal, there is another question. If patent filed in India, is it valid in other countries also?
No. So IP is always geography specific. That means if you are filing it in India, your protection will be within the geographical boundaries of India only. For getting protection in different countries, separate application in every country needs to be made.
I think the next is again the continuation of the same, which you already answered, that or we need to file the different patents for different locations. I think that's the end of the questions. So participants, do we have any other question? Though it's a bulk of questions you already asked to our expert. I think that's enough. All right. Thank you so much, Kushal. Actually, from the number of questions in the chat, it really simply let us know that how informative the session was, and students were really, into the session, and they were actually into the all the key points which were told. And I think the way many of the startups, they actually fail because of the lack of the technical knowledge, which people are generally afraid, as per number of people I have connected to. um, More of the startups, they are afraid, entrepreneurs are afraid to discuss the things with the other people, from the as they are scared of it not getting stolen away.
Yes.
So I think today's session was really informative for all the people out there, all the listeners. And on the same note, I thank you a lot for sparing all the time here.
Thank you so
And
much.
thank you so much. It was really great session. Um, so may I request IT team? Yes. So presenting you a little, a word of appreciation from our university side in
Thank you, ma'am.
recognition to the all the efforts you made to make up to the today's session. We'll be sharing this over the mail with you. And thank you so much. Thank
Thank
you.
you, ma'am. Thank you for that. Bye bye,
Thank you
everyone.
all the participants for sparing this time for us. Thank you so much, everybody. Thank you, IT team. Thank you.
Thank you.